Good evening, Canby, and welcome to our regular meeting, Monday, March 11th. We will get started with a Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right. We have two consent items for this evening. The first is draft meeting minutes from January 22nd, 2024, and then draft meeting minutes for February 26th, 2024.
And Chair Ellison, just a small correction on one of these. I was noticing this right before the hearing tonight. The labeling on the ones for February 26th, the footnote is correct on the bottom, and both of them are labeled as January 22nd. The one that has the footnote on the bottom as February 26th is the February 26th meeting minutes. The other one is the January 22nd meeting minutes. So just in case somebody saw that, but just wanted to point that out.
Thank you. So starting with the draft meeting minutes for January 22nd, do we have a motion?
I make a motion that we approve the draft minutes as presented to us here tonight. I can't remember the number of it.
Draft meeting minutes, January 22nd, 2024.
Yeah, January 22nd, 2024. I move we approve those as submitted.
Any discussion items on that? Do we have a second?
I'll second.
All in favor?
Aye.
Aye.
Aye. The ayes have it, 7-0. We approve the draft meeting minutes of January 22nd, 2024.
I believe I have to abstain from that one. I wasn't present, and I don't think you were either.
On January 22nd? So we're approved 5-0. Okay, there we go. Thank you. Let the record show that both Ellisons were gone. Draft meeting minutes, February 26th, 2024. Do we have a motion to approve those minutes?
I'll make a motion to approve the notes for February 26th, 2024.
Very well. Any discussion items on that? No? Do we have a second?
I second.
All right. All in favor of approving draft meeting minutes for February 26th, 2024?
Aye.
Aye.
All, let's see, yep, that's, that is a 5-0, I'm sorry, 7-0 vote. We got it. Approved meeting minutes. Thank you for that. Next up is citizen input on non-agenda items. This is an opportunity for members of the public to address the Planning Commission on non-agenda items. Each person will be given 3 minutes to speak. Staff and the Planning Commission will make every effort to respond to questions raised during citizens input before the meeting ends or as quickly as possible thereafter. You may speak on non-agenda items via Zoom. To use Zoom, please send an email to public comments at cambyoregon.gov no later than 3 p.m. on March 11th and provide your name, the topic you would like to speak on, and your phone number. Do we have any citizen input on non-agenda items?
Anyone online?
Nope, no citizen input. Very well, on to old business, there's none, new business, none, and public hearings, none. Planning Commission will meet in a work session to discuss the following topic, hearing procedures and processes, presented by Don Hardy, Planning Director, and David, and I don't want to butcher his last name, how did I pronounce it? Duman. David Duman, our city attorney from Barry Elsner and Hammond LLP. This work session was originally scheduled for the 26th, but was rescheduled due to staff availability. So with that, I'll turn it over to Planning Director Hardy.
Thank you, Chair Ellison and Planning Commissioners. This evening, want this to be an interactive discussion tonight, and I wanted to cover a few topical items We usually do a refresher course, and I'm still looking for one for the Planning Commission to attend. Those are usually online. They're usually through Department of Land Conservation and Development, and they usually talk about things like how to stay out of hot water. For planning commissioners, that's usually their titles. I figured tonight would be good, since we didn't have any hearing items, to go through a few items, both process and procedures tonight, starting more with the hearing, thank you, Lenny, hearing application process and going through that. And David has volunteered to, field any questions that we have. I wanted to do an overview of the kind of the major process elements, and then diving into more of the hearing procedures at the back side of this. There are questions as we go through this. This hopefully will be good discussion, dialogue on this. And David, we haven't really rehearsed this, but I figured that I could start out maybe with an overview, and then we could come back and go more in depth with topical items as we go through those, if that works for you.
That sounds great.
Okay. Yeah. So I just wanted to cover tonight, we're going through role of the Planning Commission before the hearing, during the hearing, closing of the hearing and decision, review of application materials on the record, unbiased and impartial review, and ex parte contact. So I think before the hearing, and David, I'm going to kind of seed the conversation here on this, and there probably will be other planning commissioners that have other commentary. But before the hearing, these are things that I'm hoping that we could cover about ex parte contact, not having conflicts before the hearing, what evidence is being considered in that bucket. And then during the hearing, the legal rights to process of the applicant, the opportunity for evidence to be reviewed, giving equal time, getting answers to questions, closing of the hearing, weighing the evidence is the primary factor, I think, there. And then review of the applicant's materials, that they're based on clear and objective standards. They may have discretionary elements in them, and I was hoping that we could spend a little time on discretionary. What are those, and the evolving nature of discretionary applications, given the state mandates that are coming down in House bills and Senate bills. I wanted to spend a little time on that, because that is changing the landscape to some degree on what we have as a city as discretion and what we don't. And then the next one would be unbiased and impartial. So the fairness issue really is in play there. And then ex parte contact before the hearing, and the transparency if there is communication outside of the where people are looking at sites or talking about information with applicants, those kinds of things, revealing that in a transparent nature, and also the boundaries around discussions with other planning commission members. So those are the thoughts I had, David, on that, and I thought maybe we could just clip those off, and then we could get into, at the end of this, we could get into maybe the procedure part, which I think there's some questions some of the planning commissioners have on processes and procedures, but I thought we would start with these outlines. So before the hearing, David, hopefully that all made sense, but did you want to give your thoughts on just going through and clicking through these one at a time?
Sure. Yeah, I'm happy to do that. I think it's something that for those that don't know, I think it was 26th last month. We kind of briefly sort of touched on this a little bit. So I've been practicing for I guess almost 23 years now. It's remarkable. And I'm mostly
David, did I hear you, this is Jenny Driscoll, did I hear you say that it can be considered ex parte after the hearing as well? Are you asking for us to disclose it if it's already closed and we're just voting on it? Or like what guidance would you give us specifically to when you feel like we should be reporting any conversations that happened after something had been closed and voted on?
So, if it's, this is where it gets a little bit murky, but if you've already, planning commission's decision is fine, right? If it's been signed by the chair, that's how you do it, and it's out of your hands. I don't think there's any issue generally. We'll keep talking about it with people. It's really the piece, and this was a case that came up years ago, not with me, but with entertainment. It's that piece between the closing of the hearing and the deliberation, and that final decision will be back to the planning commission.
Okay.
If you had a discussion during that time and then, Dawn returned to you with the final written decision for signature, I would want you to report it at that meeting where the written decision is going to occur. That would be technically the right way to do it. But I'm not saying that, once the decision has been finalized, that you have to, be coming back to the planning commission if you're having conversations. Once it's out of your hands, I don't think that's as much of an issue anymore.
Okay, thank you.
David, just a question. So when there is the beginning of our hearing process and people are disclosing so I think part of that is that social media piece is kind of interesting because that's not something that we necessarily have really addressed as much, but people clearly have identified as planning commissioners, have they visited the site, those kinds of things. some advice on disclosure if someone actually did see something in the paper? I mean, can you give some direction for the planning commission?
Yeah, and honestly, sure, absolutely. So I think the easiest thing to do, because it sort of relieves people of having to try to. So again, the advice is, if you're online, you see a thread or a discussion about application X, my strong preference would be for you to just not read that. As difficult as that might be sometimes. But if you do, or if there are planning commissioners that do read it, or even go a step further and kind of engage in a discussion, I really would have you not do that, because that starts to tread into potentially issues of bias that we're going to get into in a second. But if that happens, certainly give Dawn a heads up beforehand, if you can remember to do that. And then I think the easiest way to deal with it is for the planning commissioner or commissioners to say, hey, I read, a Nextdoor post or a Facebook post, whatever the, particular application is. And I want to get that, in the open, and then actually print out and submit into the record, if that's possible, whatever the post is, whatever the thread is, and just have that, be part of the record. And because that's really, again, the key thing is trying to make sure that it's not so much the fact that those conversations have happened or those interactions have happened. It's letting everybody else know that's participating in the hearing that those things have happened. And so there's kind of no better way than to really actually, if it's something that's been, done online, just to be able to print out and submit for the record, a copy of that thread or, interaction, whatever it might be. And that also, sort of relieves the planning commissioner that may have read it or participated in it and having to go through a, sort of long, detailed explanation of, what it was, and, what they did. They can just point to, we're just putting that in the record. We've done that in other contexts for cities, and it works just fine.
And David, just a little bit maybe more on the planning commission kind of acting as a jury would be helpful. That the context, is my understanding, is that the record is all they should be reviewing for the decision. Yeah, certainly. Yeah. So, in a quasi-judicial context, and that's mostly pretty much what we're focusing on tonight, right? When you're basically getting land use applications, somebody submitting to seek approval or denial of something that they want to do, and all of you are going to be judging that, right? And so that's the quasi-judicial piece. You're acting a lot like a judge. All of this mirrors what we expect of judges that are actually in black robes and considering lawsuits or criminal cases. Same type of standards where you don't want, or if the judge has had discussions with people outside of that trial or hearing that we expect, it's required for the judge to say, hey, I want to give everybody a heads up. I had this conversation. That would be the judge's way of disclosing, what amounts to an ex parte contact. That kind of leads, though, into the requirement for what we talk about with bias and conflicts of interest as well. And I can kind of go into those if there's not much more on ex parte. So I think a lot of times people will think of conflicts of interest as being what is really bias, and not making kind of the distinction that's sort of separates the two concepts. So bias is, again, this is in a quasi-judicial setting. When you're acting as a judge, the law expects you to be unbiased. So it's not that you don't have opinions about matters. The law also recognizes you're human beings, and of course you have opinions.
but that those opinions you can kind of set aside and just be able to review an application, on its merits. What the facts are, what the code says, and notwithstanding or despite, your maybe personal feeling about an application or an issue, that you're going to review it, that way, unbiased, with just respect to what's before you, what's been presented, as Don said, not necessarily, things that are just, casual observations, but rather what's the evidence in front of you? What are the facts being presented? And treat that with objectivity, being able to look at it for what it is, and being able to compare that against your standards in your code or in state law. So bias is really about when somebody can't do that, when their feelings or perception, or maybe it's, it could be because you have a relationship with the applicant, right? That is very strong in whatever way. And I have these, we all have these, where it'd be really hard to be able to objectively, review and rule on, something that maybe is coming from a good friend or a neighbor. That might be an instance where you'd say, you know what, I really can't say I'm unbiased. I can't get past this issue, and I think that would lead me to, potentially not review these matters before me objectively. And so if that were the case, that's a time where you'd say, I can't sit to hear this. I would not be participating in the matter. But again, it doesn't mean that you don't have an opinion, because everybody does. That's just natural. It's just that you can't put that opinion aside. And it maybe sounds like a higher or a more demanding sort of standard than it is. It's kind of this, in the law, we have a lot of this reasonable person test, and that's really kind of what it comes down to is, would a reasonable person sort of think that maybe your prior actions or something you've said before, would indicate that you can't objectively, make a decision. I would suspect for, 99% of the things that will come before you in your term as a planning commissioner, you're not going to be biased. You might have an opinion, but you wouldn't be biased, for legal purposes. You'd be able to do that, as the law expects. And so a conflict of interest, on the other hand, is different insofar as it relates only to financial issues. It may also sort of be related to bias. If you have a financial interest in the outcome of a case, it's probably going to make you biased as well. But the term is really limited to just having whether the decision you're going to make is going to result or affect you financially. So it could benefit you financially. It could also hurt you financially. Either way, that's what we're talking about with respect to conflicts of interest. And there are two types. They're not created equally. There's a potential conflict of interest. So that's one, as it sounds, where the decision you make might benefit you financially or negatively affect you financially. And then there's an actual conflict of interest where it would benefit you or hurt you financially. Either one, you need to disclose it, just like we would do with an ex parte contact. You have to, at the beginning of the hearing, say, hey, I have this potential conflict of interest. What's an example of that? The classic example, excuse me just a second. The classic example is, and one that comes up, somewhat commonly, given what the work that you're doing is, and the membership of planning commissions, is like a realtor in town, right? That may have a really thriving, practice, buying and selling property or representing people in that, whether it's, residential or otherwise. But let's just say they're a residential broker, and the Planning Commission is hearing a subdivision application. And that planning commissioner, who's the realtor, has had prior work on behalf of the person who's subdividing property. Sold some lots for them, or if they happen to also build the houses, maybe sold houses for them. But in any event, in their past, they had a financial relationship with the applicant, but nothing pending currently. It's not that they're engaged to go in and sell lots. I would call that a potential conflict of interest. You have this history of a relationship with the person that's before you. The decision you make may benefit you financially. We don't know that, or hurt you financially, most likely benefit you financially. That's not a will, it's a may. And so that's, to me, sort of the example. And these are actual cases that have gone to the Government Ethics Commission, and with realtors especially, it's just one of those things that comes up enough that they've heard this, more than a few times. And then flip that, if you actually are engaged, or have some present commitment with the applicant to be, working property deals with him or her, I would say that's an actual conflict. It's very, very, very likely that decision you make is going to affect you financially if you have already, an understanding with the applicant about the very application you're considering. So both of them you have to disclose. If it's a potential conflict of interest, once you disclose it, you're free to participate. You don't have to recuse yourself. However, if it's actual and it will affect you financially, after you disclose that, you cannot participate at all. I mean, whether it's in the discussion, certainly in the voting, our advice to clients is the best practice is to actually, remove yourself, go into the audience, or if, we're talking in a virtual world, maybe shut off your camera and your mic. But it's really critical for your benefit, that it's not, you're not seen as having any influence over that ultimate decision if you have an actual conflict. Potential conflicts, it really depends a lot, I think, on the kind of work that one does. And again, because we're talking about real estate matters and real estate development, anybody that works in real estate should be kind of thinking about this a little bit more. Maybe than others. That's not to say it couldn't come up for other people, but it tends to come up mostly for folks that do real estate work. So again, the distinction, potential, actual, and either way you want to be bringing that up and disclosing it, that's required. But if it's potential, you can continue, if you choose to, it's completely legal, and I would say most people do. You can continue to participate, continue to vote, treat it like any other hearing. It's just like an ex parte contact, you've got to get it on the record. Any questions about either bias or conflict?
It's not so much a question. I would just throw into what you've just said that in our process, once that conflict is declared, that we ask anybody in the audience if there is a problem with what any of the commissioners have said. And the applicant or the anybody can say to well, I've got a problem. So it's really important that if you think, well, I'm just going to slip this by, the applicant may say, wait a minute, I've talked to so-and-so, you're doing business with this person, and it goes down the drain from there. So there's a repercussion. It's really important to keep this pure. And so there's a repercussion that can happen that can be very embarrassing for a commissioner if they say, no, I have no conflict, or whatever, and then there is something brought out to light, because it will come out. So you might have comments on that.
Yeah, no. Those are really important ones too. I mean, you're 100% correct. I mean, that's why in the script that you'll read, or the process that you'll go through, there's that opportunity for the anybody, as you said, to after those disclosures are made, to raise an issue, raise a challenge, ask a question. It's actually to the benefit of the city in the long run, and to you individually, to disclose these things, because with respect to conflicts of interest, again, financial matters, that is subject, that the conflicts of interest are part of the Oregon ethics laws. Bias is not, and ex parte contacts are not, but conflicts of interest are. And what I mean by that is that someone could take that all the way up and have to the state, to the Government Ethics Commission, and that can be the basis for a fine against you, in your personal capacity, if you did have a conflict, even if it's potential and you just didn't disclose it. I mean, normally they're not going to fine you for that. They're going to, write a letter, and unless it's something that's happened over and over. But if it's actual and you didn't disclose it, and a member of the public, or somehow it becomes a topic of discussion, that can be, personally to you as a commissioner, a legal problem. Not to mention the optics of it, and how it can be, obviously bad for the city and the decision process that you're making. So yeah, I mean, I second that entirely. Like, you just want to be, if you're not sure, this is where, like, being kind of, having trust and recognizing, that you can reach out to Dawn, to staff, if need be. They can reach out to me. No one's gonna, these things happen. I mean, it's not if you have a conflict, it doesn't mean that you've done something wrong. You have relationships, sometimes they're business relationships, and sometimes those will just rise to the level of you not being able to participate. It's not because you did something wrong. It's just the nature of maybe what you do. But I think it has that sort of feeling of like, oh gosh, I have to declare a conflict. That's not good. And I get that. I mean, no one, I think most people would probably not want to do that. But it certainly doesn't, it's not an indictment of you at all. And for the reasons discussed, it's really important to get it on the record.
David, thank you. I thought maybe a good segue would be, I think we're bouncing a little bit across these icons, but in terms of like,
Sorry.
no, it's all good. You've covered a lot. I was going to say, like, I think it'd be helpful on clear and objective standards versus discretionary standards, and then weighing the evidence and basis of approval, basis of denial. I think that would be a helpful segue before we'll go into that. And then the final piece will be, we'll go into procedures, which will be like the order of how the hearing is structured. But I thought spending a little time on clear and objective standards in your experience and kind of what those are. I see those as like conditional use permits, plan unit developments, variances have discretionary elements, and also deviations from the code that are built into the code for everything from parking to height issues or those kinds of things. So a little bit of that would be helpful, I think, and that will, in context of, I think this will be helpful in terms of the level of information that Planning Commission has a comfort with to make a decision.
Sure. Yeah, you bet. So clear and objective standards, and I understand, from talking with Dawn that, this has been a topic that you, like virtually every other planning commission in Oregon, has wrestled with a lot recently, with good reason. So I'll say out the gate that I don't know if it helps or not, but it's really important to remember that, in land use planning generally, and certainly throughout every city and county's code, it is often, a subjective exercise on some level. It's very difficult to write code language, especially the way that, and I won't go down this rabbit hole, it's a topic for another work session maybe, but especially with the way that LUBA and the courts have interpreted this requirement for clear and objective standards. It's very difficult to do. And so, but if it helps at all, remember that the requirement that you only consider clear and objective standards, it only applies in the context of housing applications. Okay, so if you have an industrial, development, if you have a commercial development, there's no prohibition there with respect to clear and objective standards, and your code is inevitably full of them, right? It's like I said, it's to try to come up with a set of code standards for housing, which is again where it's required, that is clear and objective, it's difficult enough. So thankfully, we still have the ability to kind of consider most of the kind of classic land use standards in the context that Don was talking about, design review and conditional use permits. If the application before you is not housing, all right, it doesn't relate to somebody residing in a house, then really the clear and objective piece is not something you need to be terribly concerned with. However, most of what a lot of, especially suburban or, areas like Canby where you're going to be considering are a lot of housing applications. And so naturally, this is something that you're going to confront over and over again. And so, so much of it comes down to how much, we can do for you, or the city can do, with respect to its code, to try to make standards, more clear, less subjective. And I know again that you're having some of that now. You're doing that, and I guess I'll say that don't be surprised if that kind of process were to kind of continue in years to come, because like I said, it's almost inevitable that what looks clear and objective to most of us sometimes still will not be clear and objective enough for LUBA in the courts. It's a very sort of difficult exercise. And have you had, Dawn, situations where applicants have tried to really lean on this requirement in an effort to get a certain result? Is that something? Have you had people basically saying, you can't make that decision, or you can't apply that criteria, it's not clear and objective?
There's not been many that I can recall where we had that circumstance. What's going to get interesting, though, is those applications that the Planning Commission may actually not see with the new legislation that's come through the state. For example, the Planning Commission may see a regular subdivision that comes through, and that would be approved by the Planning Commission, but Senate Bill 458 would allow a type 2 process to occur, which would not be at their discretion to come back and further subdivide those down again in half and put a duplex serial lot line in each zero lot line on each lot. So there's those pieces, and then I'm not 100% sure on the Senate Bill 1537, the governor to cite, I believe she's signing this week, was approved last week, has a number of built-in called adjustments, which are basically minor variances. And it was either 10 or 20, and I'm not sure, and David, this might be another reporting back to the Planning Commission, I'm not sure if those will remain as type 3 processes for the Planning Commission or not. That will be where the testing will be at, because I think we probably will see more of those, because that legislation, that Senate bill, does have those built-in adjustments, and those will be for things like setbacks, and it covers a gamut of things that you could get adjustments for, which are basically were preempted as the city from being able to regulate those. I think that's coming. I don't think we've seen a lot of it so far.
That's good. I mean, just in terms of, that could be a reflection of the fact that this would be nice that, your code is not as subjective with respect to housing as other codes are, or you just haven't gotten lucky yet. But it's a thing, and I say that obviously, glibly. I mean, it's really difficult, and it is. The issue comes down to that, if you have this, application for housing, 100 lot subdivision, whatever it might be, and, almost inevitably, those are going to generate a lot of community interest. Naturally, it's just, almost comes to the territory. Then, if it gets to you, as most would now, as Don said, that may be changing, but as most would now, if that applicant has, somebody either themselves or they're working with somebody that has an understanding of this, what happens generally is that you have, your neighbors and folks and even yourself, your staff, your city attorney, that are saying, there obviously are maybe some issues around traffic, or some issues around, design that may be, you can take your pick, the things that generally kind of come up. And a lot of times, when you go as a planning commission to say, okay, well, let's look at this traffic issue, right? And let's give a look at what our code says, and we know that we have a standard in our code. I'm not saying you do, but just as an example, that would say, ultimately, the amount of traffic that the project generates, must not be, an unreasonable amount, for the given neighborhood, or something that kind of tries to tie it back to, being harmonious with, its new neighbors, where this development's going to be. Those will be the things that, somebody that's working with the applicant will generally be like, you can't apply that, right? What's harmonious? What is reasonably, acceptable? The words that we often use in a land use code, and that historically have been, perfectly fine to consider, are things that become almost impossible, and you're, in a really sort of ugly situation. And I really do hope that that's not something. I'm glad you haven't had to deal with it, and I hope you don't. But many cities around the state are facing this, where you end up with, a really, really very adversarial hearing. If there's a denial, ultimately, because the planning commission feels that, these standards are just not met, it's almost inevitable that these days there will be an appeal to LUBA. And I'm not saying this is a matter of like trying to be the scare guy. It is just factually the way this has turned out. It's, look at the LUBA reports, the decisions they make. And I don't think there's been a city that's won a case before LUBA on a clear and objective matter in like 2 or 3 years. They've all been subject to, reversal by LUBA. So LUBA will say, yep, you applied a standard that's not clear and objective in denying this application. So we're reversing your decision. We LUBA, are literally approving it. And the law allows them to award attorney's fees to the applicant. So the hammer's huge. I mean, it's really, really, and some clients sort of said, well, does the legislature realize, like how this is kind of happening? And yes, they do. I mean, I'm not trying to cheerlead that, but yes, that is part of what's that saying that my son was, it's a feature, not a bug, right? It's not like an error. Like that is part of the process. They are really trying to make, especially with housing, right? That's the key thing. They want to have as much predictability and really as little, I won't say local control, but as little amount of local discretion when it comes to those housing applications as possible. And as Dawn alluded to, there may be, depending on how people treat it, there's the potential for you to have all cities have further divisions of lots to address middle housing. And the way that bill is written, you wouldn't even see that. That would be something that Dawn makes a decision on. It's required that it not be subject to an appeal to a planning commission or a city council. If there is an appeal, cities have to appoint an independent, like a third-party hearings officer. And that's the way those types of land divisions are addressed. So again, I'm not trying to do this to be, heavy-handed. It's just in fact, it's the opposite. It's to try to, make sure you realize like this is kind of what you're facing now with respect to housing, and it just makes that process for you when you're tasked with making a decision on it more frustrating for sure. That's maybe the most charitable way to put it.
David, just a kind of follow-up. So the clear and objective standards, I would believe, would be things that are quantitative. Setbacks, percentage of impervious surface, building height, parking standards would be ones I believe would be clear and objective based on quantitative numeric standards. Can you give some examples? And we're updating our code as well, and to be honest, I'm not 100% sure that our design review, we have a scoring process, is like meeting the state standard right now, but that's a question on where's the line on the discretionary piece of this that is where the state is saying that's not clear and objective. I mean, can you have a design standard with scoring that is clear in terms of how we're scoring it, but I'm struggling a bit with the discretion piece on both residential and industrial, because I think staying kind of within the box of what we're required to look at as the planning commission and a staff is it has to be in the code. First of all, we can't go outside the code to bring in like things that don't apply. But have you experienced something like this where there was testing of that by either through litigation or in another city?
Yeah, certainly. And so it's a rather ironically, it's a very subjective standard as to how they determine what is clear and objective. It's basically whether the test that's come out of the Court of Appeals is, and again, just talking housing here, okay? But if it requires the Planning Commission or the city to basically have what they call a value-laden judgment about a particular criteria or a particular application. So the classic examples are things like, mitigates harm to the neighborhood, to the greatest extent possible. Things that basically, as you said, Don, anything that can't be measured in zeros and ones is very likely in a housing context going to be determined to not be clear and objective. The universe of things that are not clear and objective is much, in a housing context, is much larger than the universe of things that are. And you know, I think that there are some obvious examples. You know, if you have, like I said, a standard that says basically, you know, you can't, I mean, I know you probably don't have something this broad in general, but, you know, you can't approve a subdivision until, you know, the planning commission is, you know, reasonably assured that the subdivision mitigates all negative impacts on the community, right? I mean, that is just filled with all sorts of subjectivity, and a standard like that would certainly fail. I'm not sure about the grading piece that you referenced, but I can kind of guess a little bit, and you can kind of tell me where I'm wrong. I'm guessing that to get to those points, you know, that the code, the standards employ some amount of subjectivity, you know, like, you know, excellence in design or, you know, something like that. Is that right?
Well, there's a scoring, and we'll dive into this further, maybe not tonight, but I think the scoring gives options. I don't think it's like completely discretionary, and I hear your point, and I've actually been in jurisdictions not on this side of the table where they said you need to put a building in that emulates buildings of good design. That would, in my opinion, be completely not clear and objective, and that will be an unknown,
Absolutely.
not named jurisdiction, but nearby us.
Don?
Yeah.
Excuse me. One of the things that you've been talking about to grant you a little bit more flexibility in the code is just a flat numerical variance that could be applied by staff. Do I kind of have that right? Now, couldn't somebody conceivably say, well, because that's discretionary, you're going to give me the 15% that you decide to give 15 here or there, blanket across all the numerical values just because it's subjective based on your judgment as opposed to clear and objective?
And a great question. The context, I think, we have had some work session, or a work session on like looking at administrative variances, which we really don't have built into our code except for, I believe for signs, and we allow for setbacks at 10%. But then you go into a full-on variance, which is fully discretionary on the variance criteria. David, your thought on that? I mean, if we were to just pick a number and say across the board, and that's kind of what the state is doing a little bit with these deviations already in their own legislative manner of saying, I mean, would that help us, to Michael's point, would that possibly help us in addressing some of these boundaries on, if we were to grant 10% and that was like, okay, that's what we do before you hit a threshold where you got to do a full-blown variance?
Yeah. I think critical to answering that question is knowing if the applicant's trying to seek a variance from an already what we would consider, or what I would consider to be an objective standard, so something with numbers, right? A setback. Right, that maybe is the easiest way to think about it. Like, you know, you have a 20-foot setback that's required, and the applicant is seeking an adjustment, you know, of, you know, some amount, and it's discretionary as to whether you grant that adjustment or not. I think that actually is okay. Because you're starting with an objective standard to begin with, right? Either the house is set back 20 feet from the property line, or it isn't. What the clear and objective stuff is really trying to get to are all those standards, and again, there really are historically a lot more of them. That you and I and maybe everybody in this room might have a difference of opinion on. You know, is it is it, you know, the best design, or is it mitigated to the greatest extent possible? We could all have our own sort of view of whether that's a standard like that is satisfied. But a standard that says, you know, a building has to be 20 feet from the property line, if somebody wants to try to, you know, get it 15 feet from the property line, and they go through either an adjustment process or a variance process, I think that, I mean, I don't know of a case that's actually tested this, and I'm sure we'll see one soon. And I might not be aware of one that's already occurred, but I personally think that would be okay, even if you are exercising some discretion as to whether to grant that adjustment or not. Usually those codes for at least adjustments, as I think you're describing it, Dawn, something that's not a full-blown variance, I've usually seen those written in terms of shall grant, but doesn't mean they have to be. You know, that basically it entitles anybody to, you know, a 10% shift here or there. But I personally think that if you're starting with an objective standard, like a 20-foot setback, and somebody, for whatever reason, just says, I'd really like it to be 15, maybe because they want a bigger house or, you know, whatever, that's up to them. There's nothing that's preventing them from meeting the 20-foot setback. And there's no basis for the city to have a differing sort of points of view about, is it 20 feet, isn't it 20 feet? I mean, not really, right? So I think that would be okay. But if you're talking about something that is already, you know, sort of, you know, a subjective standard, or at least likely is mushy, then I think getting into variances and such it's a much more difficult proposition.
And so the more objective this we have on their standard, the better. I did want to touch on housing briefly, and the differentiation, because planned unit developments can still be discretionary. You can allow variation with planned unit developments, but like cottage clusters or middle housing, and they are needing to meet a different set of standards. And I'd like some dialogue on that as well, because that is middle housing. So could you help us navigate that a little bit? Like, planned unit developments have discretionary elements in them. Planning Commission would clearly see those. They may also see cottage clusters, but they're subject to a different set of middle housing criteria based on state law.
Yeah. So let's take the PUD piece first. So that's a really, you know, common part of a lot of city codes, development codes, and you know, historically it's been, I'm sure it's similar in Canby's case, where you might have like constrained sites, or, you know, somewhat unique properties, or the developer wants to do something that's a little out of the ordinary. You know, maybe reserve a lot of property for open space, what have you. But usually it's because there's some sort of natural resource constraint, or it's steep, or, you know, whatever. But Don's right that those are okay, having a PUD section, and they can be subjective. But it assumes that you have a path that the applicant can take that is clear and objective. So the law says basically everything has to be clear and objective for housing. And as long as an applicant has that path available to them, then city, you can also have a discretionary path. And that's generally almost always the PUD section of a code. But it's all public. So I literally, you know, was just about 3 months ago involved in a matter in Forest Grove, where this very issue came up, and the applicant argued that they did not have a clear and objective path for their subdivision. So they had to go into the PUD, and therefore, you know, it worked out okay. There was no appeal, but they were basically arguing there that we don't have a pathway to clear and objective. We have to do this through a PUD, and lo and behold, you have a lot of subjective standards in your your PUD ordinance, and we don't think any of those apply to us. What's critical is at least in the environment that we're in now, and probably going to be for, and what I mean by that is just this world of a much, bigger, that housing is always going to be subjected to these clear and objective standards. It's trying to come up with something that is palatable for the community, that is, to almost everybody's eyes, clear and objective, and then ideally having a way to kind of get applicants over to like a PUD process by having some carrots, something that incentivizes them to do that, and then you're able to say defensively say, no, we've got this other process. You can go through it. It's all numbers. Happy to do that. You have that right, but we also have this one, and we think it'd be better for you, applicant, and obviously better for the city, because then you could apply the subjective standards easily. The middle housing piece is sort of unknown a little bit because we haven't had enough time with it. I think there's been a couple of reported cases so far, but I think it's best to assume, and the statute says this, that while there is an allowance for sort of siting standards, that cities can consider, middle housing applications and impose some reasonable siting standards. It also says that all of them should be reviewed, must be reviewed according to clear and objective criteria as well. I think that it's going to be living with this in one form or another, for the foreseeable future.
And just one final thought. So mixed use development, is that allowed to be discretionary? And the reason I'm asking that is our most intense discretionary review is in the downtown.
Yep.
Most of that is commercial, but talk about those standards that you're talking about where there's value-laden judgment. I would probably believe there is some value-laden judgment in our design standards for downtown. So just some thoughts on that. If there's housing mixed in with that versus not mixed in, it's commercial. It sounds like it could be quite discretionary. But if there's housing mixed in, is there any tested cases of that?
I'm not aware of one, but I think it's soon to happen. I think the key there is what is its zoning designation. It doesn't carry the day. I am positive that there will be people that will argue it doesn't matter. We have a housing component, and at the very least, the elements that are applicable to the housing component, you have to treat through clear and objective standards. But there is language in middle housing law that talks about the middle housing standards not being applicable to properties that have designations other than housing, even if housing is allowed on them. And that gets to this mixed use piece. So I think that if most of those properties downtown are zoned commercial, but allow for some housing, my view would be that we can take that at face value and treat them as commercial applications. And have subjective criteria, including the housing piece that might be associated with it. But I say that kind of reluctantly, and that's yet to be determined.
And that's exactly what it is. So, I mean, it's helpful to have that guidance. At C1, it's downtown commercial. So I think that's...
It's to the advantage. Yeah, that's good as far as like hoping that, we're not... but I'm reluctant to say that'll carry the day.
Gotcha. I was going to turn it back to the Planning Commission. Any other questions? And we'll maybe then dive into the procedures if there's nothing else.
Doesn't look like anybody is have any questions at this point online or in person.
So I was going to move on to the processes and procedures for our hearings. And just David, I think it would be helpful, and I think part of this is the mechanics of closing the hearing and getting the questions answered by the planning commission and procedures to get to the answers so that there's answers to the questions, not spending more time than needed to get to that, but also not spending less time than it's going to cause problems. So just, and just maybe structurally on that, it would be helpful to have, I think, some conversation around it.
Sure. So, and you can tell me if I'm sort of in the ballpark, but I know one thing that can come up for some of our clients is you have this hearing and you have a lot of information, presented. Some of it just came in that night or a day before, and you've got planning commissioners that have lives outside of this and probably haven't had a chance to digest a lot of that, or at least all of it. And so, you go through that and then you get to a point where the applicant has, let's say, had its final say, its rebuttal, and it's sort of the logical time to close the hearing. One thing you might want to consider doing, if what's happening is that, so then it's closed, and then the planning commission gets into a deliberation, and suddenly it realizes, wait, I have a question about X, or I want to ask about Y, but the hearing's closed, and so, what do we do now? You can always leave the hearing open for a little bit, even at the start of the deliberation. It doesn't mean that anybody can just get up and say whatever they want. I mean, you've gone through and given, at this point, I'm assuming, you've gone through the steps, you've given the applicant, you've given the public, those that are there, those that are online, the right to say their piece about the application. You have every right at that point to say, hey, we're going to be having a discussion amongst ourselves right now. That's time for deliberation, but we may very well have questions too. We probably will. And some of those might be for the applicant. Some of them are going to be for staff probably, but we're going to leave the hearing open temporarily while we begin our deliberation. And that way, if they do have questions, it's fairly easy to go and ask that. Depending on the question and depending on the answer, it may be something where I would say, hey, that's sort of novel enough and big enough that we might want to allow for sort of a mini, allow for some people to comment on that more than just the applicant. But I honestly, most of the time, I don't find that's true. The questions that come up are fairly, mostly clarifying in nature, and it's generally not something that takes much more than a 1 or 2 sentence response, usually from the applicant, to kind of clarify whatever the issue is. And once that's sort of been vetted, you can even go around with the planning commissioners and say, hey, before we close this hearing, is there anything more that you would like to ask of the applicant or of the public? Clarify something. You can always talk with staff after the hearing's closed. So, I assume you know that. Like, questions of us, including the city attorney, but certainly Don and Ryan, on a particular application after you've closed the hearing, that's perfectly fine. But once it's closed, to go back and try to ask the applicant or get more information, more evidence, that's really difficult. So that's one option. I don't know if that kind of gets to some of the problems, but actually leaving the hearing open for a portion of what would otherwise be, a closed hearing and the deliberation of the planning commission. Just basically leaving it open for maybe the start of the deliberation, and then once it seems that there aren't any more questions, then closing it. And then that way, at least, the chances of having a lot of other questions come up are fewer.
So, Doug, just a question on that. If you do leave that hearing open, and then there's questions asked of the applicant, that kind of gets into the weeds just a little bit, because then you're going to have to give the proponents, opponents, they're going to, if there's new information brought out, you could have a situation where they're going to say, well, wait a minute, that isn't what you said before or whatever.
Yep.
And that's kind of the purpose of closing the hearing. I mean, I get what you're getting at. It's nice to leave it open if there's questions, but it also, you're kind of leaving
Yeah,
it.
no, you're absolutely right. I mean, so maybe better, like, what is the sort of pain point that for the planning commission? Like, where does this come up mostly? Because I think the bottom line is trying to get, if there are questions, wherever that happens before the public hearing is closed, that they're asked, right? And so part of it is just making sure that there's enough discussion, both from the applicant and then during the presentation, that all of you are feeling empowered to ask questions, right? That's certainly you're right to do that. You're absolutely right. Like that's where I was getting at. Like, it can get funky. Normally, what I'm used to is that if there are questions sort of at the end of a hearing process, that they're very kind of clarifying in nature. If what is happening for you all is that there are still some real questions of substance, without pointing fingers at anybody, it seems like something's kind of missing at some point in the hearing, and whether that's we're not giving you what you need, or they're just questions that you're not asking of the public or the applicant that you're not sure if you can. So maybe, do you have a sense of like where it kind of has stung and where you found yourself? I mean, I guess with that last application, I kind of have some sense. There was that question about the pathway, the pedestrian condition. What are some other examples where this has come up?
Doug, there was one that I remember where we closed the hearing, started our deliberations, we're talking amongst ourselves, and the applicant just interjects because he or she did not either agree with what we were discussing or wanted to clarify our comments to us from the audience, and then that's where you get like that awkward, what do we do here? We're already closed. Do we reopen and allow that comment? So I would say just in the short time I've been here, we've had that maybe once or twice where we're just in our own world having our discussions, and then somebody interjects after the fact.
Okay. And it's David, by the way, just so not that I care.
Sorry, David.
So that it kind of depends, right? I mean, I would say absolutely at that point, the chair or the planning commission or staff or me, it's inappropriate. I mean, there's no, you can just shut that right off. Legally, you have the right to do that. Now, whether sometimes that, I don't know what the comment was or the question was. Sometimes there might be some merit to it, right? Despite the fact that it's out of order and, the hearing's been closed, maybe somebody, sounds off with a comment or a question that you kind of had to pause over, right? And think, well, geez, we didn't think about that. And there's not a perfect answer to this, but it's really trying to figure out how can we flesh those things out during the hearing. It's almost inevitable that once in a while these things are going to happen. But if it's happening kind of routinely, then it seems like there's something maybe that we need to kind of address during the hearing. that could be something where, maybe during public comment, if this is a member of the public that this was the applicant. Trying to think of just how to practically address that. Ensuring that, the applicant has sort of said everything it wants to say. I guess if it's happening a lot, I'd want to know kind of more of the specifics to figure out if I think it's something that we can actually address and, sort of do it in a way that doesn't create other problems. How did you handle that particular example? Like, what did the Planning Commission end up doing?
And can I give more of a generic situation? You have a very controversial project comes in, the applicant gives their presentation, then followed by an hour-long testimony, perhaps, of people that are oppositional. Mm-hmm. The applicant comes back and does rebuttal, but does not actually address all the issues that came up in the opposition. Okay. That's where it becomes extremely awkward, because then the planning commissioners are thinking about, well, that other issue never really got addressed. And that's my perception about where that starts to get sticky. A lot of these don't need a lot of labor. Some issues are like everybody's on board, there's plurality, or there's consensus, and there's just a really quick question at the beginning, like, this is a slam dunk. But it's the ones where there's a lot of public testimony and the applicant may or may not really address those appropriately, or to the extent that the planning commissions feel a level of comfort with it.
Is somebody insisting that they do? Because
no, I'm not saying they do. That's my perception, though. I'm not. Can't speak for the planning commission, but
if, let's just say it's clear there, whether it's spoken or unspoken, that the planning commission, the applicant hasn't really addressed in rebuttal all the stuff that was raised and that you would hope that they would or expect that they would. I mean, every right to, and you should, somebody should, say to them, well, what about these issues? These other things were identified by the public. What's your response to those? Hold them to, it's their burden, right? They have to convince you that their application is provable. Some of that stuff I've been through, hundreds of these, so I get it. Like, especially the more controversial it gets, either that could be, more difficult to ask, or you may have a lot of sort of extraneous things that aren't really related to a code criteria. But I would say that if, there's opposition testimony that's brought up and it is reasonable and it kind of at least generally relates to the code or a criteria in the code, and the applicant's not addressing that during its rebuttal, and that becomes something, that the Planning Commission wants to know more about, or hold them to that and say, hey, what about these issues? Maybe go around with the planning commissioners and say, we've heard rebuttal. Before you kind of let them go, say, does any planning commissioner feel that the applicant hasn't really addressed, all of the public comments or something? Just sort of check in. And then that way, that can be the basis for, well, I don't think that they really addressed this piece, and I want to know more about their response to that.
So we effectively give them an extended rebuttal period?
Yeah, well, if it's a piece that's going to be important for one of you or most of you to make a decision, absolutely, yeah. Yep. You can do that with, usually the way that we treat questions from commissioners is that it doesn't count, certainly true in courts, it doesn't count towards a time limit. So if the body that's charged with making the decision is going to have questions for, in this case, the applicant on rebuttal, let's say it's a 10-minute rebuttal or 5 minutes, and not, whatever time limit you might impose. If you have questions of the applicant, that doesn't, we usually don't consider that counting towards that time limit, for the very reason that it's information that you need to be able to make a decision. And it's certainly preferable to then having this thing on the back end where you've closed the hearing and now you're having these questions and you don't know what to do.
And there may be other circumstances. That's probably not the only situation that happens in, but that, David, I think is what I observe anyway. I mean, I'm trying to visually see people mentally process things. I have no idea what they're thinking, but and part of it is like they're grinding away, like thinking like, how does that get addressed? And some applicants are better than others in terms of doing
Absolutely.
that.
Yeah, no, that's very true. But I guess, it's never going to be perfect, right? But the more controversial an application is, inevitably almost the messier these issues are. But I think that, I would say try to prioritize instead of the process, we said 2 minutes for the, public and 5 minutes for the applicant. And you should do that. I mean, I'm not saying like just allow for endless testimony, but whether it's members of the public or the applicant or, anybody that participates, if one of you or all of you, or some of you have a question, you should prioritize that, getting that answer from the public member that testified, maybe a neighbor who, you want to know more about their concern, or the applicant, certainly. Prioritize getting that response versus the amount of time each is allocated, because I think in the long run you're going to actually save yourself a lot of time and just this frustration that comes. It's difficult. We're asking you all to do some really difficult thinking about this stuff, particularly when it is a controversial case. And at the very least, you're entitled to kind of have all your concerns and questions addressed. If not, to your satisfaction, if it's not the answer you want, at least you're entitled to be able to ask it. You should be able to feel free to do that.
Other questions?
Just the time that we allot, are those times prescribed, or are they kind of arbitrary? In other words, 2 minutes for this, 5 minutes for that. Can those are just kind of a great guideline, I'm assuming, and they can be adjusted as long as equal time is given to both parties, correct?
Yeah. I mean, unless you've got something. So state law doesn't address anything about time limits. And I have to apologize. Given the nature of my role and coming in, when I don't know your code all that well. If there's something in your code that says that, then, that's different. Like you sort of impose that on yourself. But assuming it's just coming from maybe, the consensus of the Planning Commission or sort of just the way we've done it. Yeah, absolutely. Those can be on a hearing by hearing basis, something that you can account for, right? Like I also serve as a hearings officer. I do work for Washington County, other counties. So, I'm basically doing doing the same thing you are. And I will, say if I know something is going to be, or I have a sense that something's going to be very popular, a lot of attendance, a lot of comments. I sort of build that in, and I'll just, get a sense of it and say, all right, for this one, because there is going to be, either something that just seems more complicated or whatever, I'll adjust those. It is important to have a balance, right? But there's not really any like hard and fast rule, unless that's something that we've done internally and impose that kind of on ourselves. And we can address that too. That's the case.
And we did make some adjustments, David, with time limits, because when I first got here, the applicant was staff and we would present for like an hour. And I'm like, why in the world are we presenting for an hour? And so we reversed that, and probably not giving ourselves enough time, but by our code, we're giving ourselves 5 minutes of staff. Sometimes it goes over. The applicant has 20 minutes. They have the burden of proof. Then proponents, I believe, have, is it 5 minutes or 10 minutes, Laney? 5 minutes proponents, 5 minutes opponents, and then rebuttal is 10 minutes. So we have prescribed that, and it was intentional to bring the applicant back into focus to be the carrying the burden of proof here.
I think that is I think that's a very good way to approach it. I totally hear you. There are some times where staff reports will be far too much in the weeds, and it's really more, that's the applicant's job to give you all that detail. I think it's important for staff to be able to fill in if we have a sort of take that maybe technically the applicant didn't address, and we sense, hey, that's going to be something that I think the Planning Commission would really want to know. I think we should, supplement that as necessary. But yeah, I totally get that, Don. And I think those timelines sound really, pretty typical. Trying to kind of have a staff report that, lays it out but doesn't get into all the details. Applicant, it's now your turn, it's your burden, and we're going to give you some more time. Now, those numbers sound very, very reasonable to me. I guess what I would say is that, it's up to you all. I mean, it's your decision, and kind of these issues better than I do in terms of how to run it. But I would say, again, like if you're into the fifth minute of a member of the public and they actually are raising something that generates, questions amongst some of you, I would absolutely say ask that question, even if that 5 minutes turns into 15 minutes. It's not ideal. I mean, don't get me wrong. It's just that there's, you can't have everything every, way you want it, right? Like, I don't mean that to sound condescending. It's just sometimes something's going to give. And I think it's better to, get everything that you think you need at that hearing, even if that means it's going to maybe run longer than you'd hoped. And this is probably only an issue, I'm guessing, like you said, Don, when it's, a controversial or complicated application. Most times, hopefully you don't have to, you can go through that 5, 20, 5, 10 routine and be fine. Probably get done much sooner than that.
I'd like to touch on that if I could, this Judy. So backstory, in the town where we have our winter home, one of my neighbors is a planning commissioner for the town here. It's 30,000 people and growing as fast as the town could grow. So they have a lot of things coming to their planning commission. So we had lunch, kindred spirit. What do you do? How do you do it? How do you manage that? And, there's all sorts of styles and differences, which are really interesting. But one thing they do, which I like, but it's mostly with the larger development folks that come in with a slew of, sorry, David, but they come in with a bunch of attorneys and they have a very large PowerPoint that, they're not being respectful of time. It's not so much an issue when they're people from the public, but what happens then is if it's obvious that they're just oblivious and they're just going to keep going on and they're not being respectful of the time, then the chair stops that person and says, how much
time's
more
up.
time do you need? Pardon?
Yep, you got to wrap it up. Yeah.
Now, and he says, how much more time do you need? If they say, well, I need 10 more minutes, then the chair says, well, then I'm going to call for a motion to set aside our timing rules. And he waits till someone in the planning commission creates a motion in a second, because sometimes people tend to abuse that a little bit. But that's, to me, it's a style thing, but it's basically saying to somebody, hey, we take this, we do take this pretty seriously. I totally agree. We should give people as much time as we can. But sometimes it's not about that. It's just they've come in, they know they have time, 20 minutes, and they come in with a 30-page PowerPoint, and that just doesn't work. So anyway, that's just something to consider. Make
Absolutely. Yeah, no. So just to be clear, I don't think that, I think time limits are really important, and I think enforcing them are really important, right? I think that you have every right to say, hey, you're almost at 20 minutes. You've got to wrap this up. That's only fair to the other people that are just going to have 5, right? I mean, so I only mean that, if you don't have any questions, there doesn't seem to be really any, thing that's generating any sort of like, then, I'm a big believer in sort of, nicely. It doesn't have to be. There's nothing rude about it. You've laid out all the rules in advance. You're just reminding them that there's a time limit and enforcing that. But if you do have questions, then I think it's absolutely appropriate to use that discretion. It's our time, right? We're setting this, and we have the right to vary from this if we think basically that we need more information from one of you who's subject to these time limits. It's really only if you're finding yourself, which it sounds like sometimes happens, how do we get more information, that we need to really make an informed decision? Some of that's going to be, wanting it sounds like some questions that may come up that really aren't answered. And I think, if a way to address that is to basically say, the applicant may be close to at the end of the rebuttal or their presentation, but there's these outstanding issues that we got to get addressed and we got to ask them. I think that's well worth the time, as well as it really benefits, I think, your time and the process, the decision you're going to make.
Yeah. The other thing that came up with that when I was having my lunch here is somewhat related in that what I see also happens is sometimes our applicants, they'll bring in a PowerPoint, and that's nice, but we don't see the PowerPoint in advance. And so it's different than the application. And then we're kind of put in an awkward position of trying to reconcile what they're presenting versus what the actual application has. Yep. And I think, so when I mentioned that here locally, they said they don't allow that. They have to turn in their PowerPoint in advance.
Yeah, so I think in Oregon, the way that I can't point you to I kind of can. The way it's been that ultimately the law works here is that anybody up to the hearing itself, at least in a quasi-judicial setting, can come with additional information, additional testimony, additional evidence. And we, for better or worse, have to kind of work with that. I'll give you some practical tips, though. I don't, again, every sort of situation is a little bit different, but if that's the applicant, that's where that's happening mostly, or you get like you have the stuff that is put together before the hearing, and that's what staff has, and then the night of, the applicant's coming with a PowerPoint that might be at some odds with what you've read. Again, that is a time to say, well, why is this different? Can you explain why it's different? But it's also the applicant's burden to show that they've met the criteria. So if you're getting, sort of mixed, sort of a mixed record from the applicant, right? Something that, in one set of documents or what they said was, led you to believe that their development was, was going to result in this, but then they present you with something else that makes it seem like their development is not going to resemble that at all. That may be even, in the long run, the basis to deny the application. They have to be able to show you, with consistency exactly what they're proposing. And I don't mean to suggest that, everything would be subject to that, but, what sometimes happens if there's a lot of, depending on the applicant and their, sophistication and how big the application is, what clients will do, what I will do sometimes is just say, I'm not sure that I can make a decision on what you've presented, an approval, because there's contradictory evidence that they've given or testimony, and so one thing that you can always say is that if we could leave a record open and you can try to clarify this, we can continue the hearing. And I know there's 120-day issues there, but that's often the basis for, you can't require them to continue the hearing or extend the 120-day clock, but if the message is, we think the what you're presenting is contradictory, we don't have enough to approve this, so we're going to deny it, unless you kind of clarify these things, then I've found that most people will continue the 120-day clock pretty easily. So again, it's not ideal, I mean, it would, be ideal that you could get all that, you could, have it run efficiently and be able to make an informed decision, not have, some of that, head scratching, but it does happen. And so, the best we can do is kind of like, well, how can we work with this? And do we have to, and if you have an application that's just all over the place, it's not up to you all or staff or me to try to connect those dots. That's the applicant's job.
Yeah, I mean, it's hard to do that on the fly when you're comparing a PowerPoint to an application in a meeting. But the last time I asked an applicant about that in our meeting, he said, well, that's an older version of a PowerPoint and we've changed the application since then. That was his excuse.
That's pretty unsatisfying.
Yeah, anyway, thank you.
So David, are you saying that we can't request a PowerPoint before? Because that would be really helpful to have that. But you're saying
you
we
can
can't.
certainly, no. You can certainly request it and do what you can to, I mean, most applicants are going to want to try to please you, right? So yeah, absolutely. But what you can't do is say, if we didn't get it from you, by this time or this date, we are just not going to consider it. Whether it, might really make you angry and it's not in their best interest, but they could come that night with all manner of, information. They have the right to submit that. What we do with that, like I was sort of alluding to, we have some options, but we can't say just hard and fast, anything that the city doesn't receive by, a week before the hearing, we won't consider. We can't draw that kind of bright line.
Got it. Thank you.
But it might behoove us to request it ahead of time because most people aren't really going to want to change it dramatically from what they give to us ahead of time.
Absolutely, yeah.
And if they do change it, it's their prerogative, but at least we've got something.
They have it.
So I want to make a couple of comments. Number one is I think that the thing that Judy brought up about the motion to set aside the time rule, if it looks like it's going to be beneficial to the commission in our discussion, that's something that I've never heard of before, and I think that might not be a bad thing to explore in our process. The second thing is, back in the day when we had to do hard copies of stuff, if they were going to bring maps or if they were going to bring whatever, they had to present that at the hearing, and then they spoke to that at the hearing. Mm-hmm. Now, I don't quite see why PowerPoints are any different. If they want to... If they want to use a PowerPoint, what would preclude us from the staff from saying, you need to put this in, give us enough time to review this so that we can hold it up against the meeting that we had with you to see if what you're going to be presenting in this PowerPoint is the same thing that you're going to be that you presented at our official, our hearing, our meeting. With you in the beginning, but you're saying that we can't do that. So what you're saying is what I thought I heard you say was that we can't, anything that they use in the hearing doesn't have to be presented. It doesn't have to be given prior to the meeting so that we have that information. So legally we can't do that.
We can't say to them that, we will, we couldn't set a rule that says we will not accept any new information from you applicant the night of the hearing. We are only going to go on what you submitted, a week ago, or, whenever the packet was put together. We certainly can say, I think this was kind of like the last question, that we absolutely want to have that stuff, a week in advance, and that if you're going to present something new to us that night that, doesn't seem to line up with what you presented a week ago or initially, it's not our job to go and figure out how to match all that up. That in and of itself could be the basis for us to deny an application, because it seems like the applicant's presenting two different applications at that point.
Right.
I mean,
So it would be
cases.
very proactive of the staff to really encourage the applicant that if you're going to be doing a PowerPoint, we'd like to have our hands on that at least a week before, so that we can, so that our commissioners can review this.
Right.
And those
Right.
PowerPoints should all have numbered pages. That was for you, Judy. The other thing that we bumped up against, the other thing that we bumped up against that that I want to make sure that we talk about, is this business of reopening the public hearing. Now, there has been times in my history where we have gone in, we've closed the public hearing, we've gone into commissioner deliberation, and the commissioners, 1, 2, whatever, comes up with something. We ask staff, we say, how the applicant said that, I don't know, try to pick something. The applicant said that they would put in 5-inch diameter trees on all the streets in this subdivision. Okay, now, maybe that's what the guy said, maybe it wasn't, but that's what somebody heard. And so we're talking about, well, now we have an applicant that's jumping about 6 inches above his chair and waving his arms, but public hearing's closed. And the staff, we look at them and they say, well, that he said that, but this is the first we've heard about it. So to allow him to speak legally in the hearing, we would have to reopen the public hearing. We would allow him to tell us that he really only wanted to put in 1-inch diameter trees.
Yep.
And then you have to give anybody else time to speak to that. And
Not necessarily. I think,
No,
I don't mean to cut you off, so go ahead.
no, you're going to get in a little bit of trouble if you don't, if you let him present new well, in this particular, my example, that isn't really new testimony,
Right.
okay? But let's just say that in his response, he gives information that the either proponents or opponents feel is new information.
Yep.
We need to then let them have their say, rebuttal, and then close the public hearing again. Is that we can do it that way? And am I correct in that?
Yes, you can. It's very, as you might imagine.
It can get messy, but it's at least it gives a clarification.
Everybody being kind of frustrated, but if it is new information, right? And so I think that piece you'd want to ask first, and that'd be something you'd ask of me, or I think it is mostly the city attorney. I think most planning staff would say that sounds like a legal issue, and I think it is. And so you probably want to say, David, does this seem like new information or new evidence to you? In which case we need to allow for the public to weigh in on it, and then I can tell you either I think it is or it isn't. If it isn't, or if I don't think it is, then there's nothing that requires you, no matter how much, it's really more of a, I'm not saying this is easy, but it's really more on you all at that point, whether you want to reopen it or not. But if it's not new, there's no requirement to, and then that's on me, right? I mean, if I'm wrong and that gets appealed, then you'll be looking to me to say, why, how did we get here? But yeah, I think if it's new, it does, like I said, there's no perfect resolution to these, but that is an option, certainly, to kind of have that opening. If it's new, allow for people to comment and then close. The other thing, again, is just if that's a question that was out there in somebody's mind, don't save it for the deliberation. I mean, maybe it comes up during deliberation, you can't avoid it. But if that was something that a commissioner had before, ask it before you get to deliberation.
And David, I just wanted to throw one more thing out on the advanced PowerPoint, and that's absolutely something we can add in at our pre-application processes. We're encouraging applicants to, really carry the weight of the application. I would strongly encourage a continuance versus a denial based on lack of, clarity of information.
I would too.
Ultimately, at least in Canby, in our jurisdiction, it almost always comes back to the planning commission on remand. So really, essentially, the planning commission ends up having the vote in the end anyway, unless our council starts to change that up. We did change the text in the code because some of the prior council members thought it always had to go back to the planning commission. Well, it's their call, but if there's new information, which there almost always is, the council then usually defers it back to the planning commission, because on appeal, people bring in more information that was not previously heard by the planning commission.
So, I'm reading a little bit between lines, but I feel like maybe one of the pinch points for all of you is the time that some of these things take, and sort of an expectation that, I'm just guessing, I'm asking. Because I think
mine is more that they need to come to the table with accurate information. And sometimes their excuse is, well, we've gone through so many iterations of the application, and basically, quote, quote, the city can't get their act together, so our PowerPoint didn't keep up with this, or this application is different. Anyway, they try to make it not their fault. But it's me saying to them, get your act together, be professional, show up like a professional person. It's not so much about the time, it's respect of the process.
Sure.
It's always an option to not use the PowerPoint if it's not accurate. Yeah, and, maybe staying something in the materials that say, accuracy will be expected in presentation materials would be something to maybe move it up their agenda to make sure that it's correct when it comes to us.
I can understand how they might be frustrated if they're going through multiple iterations of an application. They're trying to keep all the application documentation, the PowerPoint in sync, but don't try to make that our fault.
It's all about really improving the process, Judy. I don't disagree with you at all. There's significant variation that I've seen, and I've worked almost in every jurisdiction in the metro area, and there is significant variation at each of these hearing processes. And I think part of it is that, again, back to staff kind of carrying the burden of the day until we changed the code and made that the applicant's responsibility. There's some education that we're continuing to do. And that's stuff that we're going to continue to push back to the applicant, but ultimately it is their burden. Oregon in particular has a pretty narrow band of getting through the approval process, and you can end up a LUBA really quickly. So from that perspective, there's not a lot of, extra appeals and stuff before you end up getting to LUBA. I'm not sure if every applicant really kind of understands that, but that's why the record is everything and is really essential to provide, especially when you all are weighing out everything that's part of the process.
Yeah, I mean, I've seen, in other places, other Clackamas County communities, Sandy comes to mind, and I get this, that everybody's going to have a different take. Hearing bodies have their own, energy, personality, depending on who's in it. It shifts and it changes. But historically, that city has been very much a community that will, if it doesn't really have, what it expects to have from an applicant, it will, be fairly clear to say, look, either, we continue this to get more from you because we're, at this point pretty confused or feel that there's inconsistencies and you need to make sure that the clock is extended in order to account for that. Or if we're going to make a decision tonight, that's going to be more difficult. not a threat. It's just really a reflection of the confusion, if it rises to that level that you're all kind of feeling, you know. I think what Don's point is really well taken, and it's that in any guise, the city should not be doing, you know, the applicant's work, and it's okay to say to them, you need to do better, right? Whether that's make it clearer or, you know, have more information in response to maybe a community member's concern or a planning commissioner's question. You know, as long as it's relating to a criteria or reasonably relating to a criteria, that's certainly within, you know, your right to do that.
Any other questions, comments? David, thank you so much for being here tonight. And as we get into applications, there's still an ongoing discussion as well. You may be seeing more of David during hearing processes. So there's some dialogue around that as well. So just, especially those that may end up rising to those higher levels we just talked about. Yeah.
You bet. Thank you.
All right, so at this point then, we will move into items of interest and reporting from planning staff.
And Chair Ellison, I have just a few items, just kind of up and coming items for you all to be aware of. April 17th, there will be a city council work session on housing needs and housing production strategies. I'm hoping to prep you all on March 25th before that on kind of a preview of what that will be. It's been a long kind of process going through the housing needs analysis, and we're going back through some granular reassessments on lands that are partially vacant and whether or not they could be further developed. There's a fairly fine lens on housing needs, and the reality of the buildable lands analysis is there may not be a whole lot of acreage demand for urban growth boundary expansion for residential. That's just cutting to the chase. And so that's the kind of preview of what the council is going to hear about. We're still going to be doing housing production strategies. You have seen some of these housing production strategies before. You will see them again. We'll be going through the hearing process for updating that, but housing production strategies, there'll be some additional ones focused on housing for the elderly, the disabled, those needing, you know, certain targeted rents, those kinds of things. There'll be more strategies around those that you'll see as part of the housing production strategy piece. But we felt like it was important enough, since we've had 3 community summits and we were talking about urban expansion of residential, and our initial consultants' inclination was that they were using modeling based on participation rates, meaning how much of land is going to absorb over 20 years as partially vacant and vacant. Those numbers that are assumed by DLCD are quite a bit higher than what the consultants were assuming, thus the lessened demand for housing. So there'll be discussions around that. If there's not a great demand for housing, I mean, there's also the governor's Senate Bill 1537 that just came into play, and whether or not they would be interested in taking advantage of the one-time 50-acre urban growth boundary expansion, which should be separate from our urban growth boundary process. But if we're eligible for that, it's part of that discussion that'll happen on the 17th of April. So as I mentioned, on March 25th, they'll give you kind of a preview. We'll talk about housing needs on that. We'll probably be jumping back into fencing. I know that's a topic you guys all love, on April 8th. So we'll be getting back into that. April 22nd, I'm not sure what's going to be on that agenda. I'm hoping that you will be seeing the housing needs and housing production strategy in hearing form on May 13th, and that would go to council on June 5th. We only have one hearing in May 27th is Memorial Day, which is also the day of the Planning Commission, so there's only one hearing that month. Then in June, I'm hoping to launch into housing efficiency measures. Again, there may be, I'm not sure how many work sessions, but we need to get back into cottage cluster, plan unit developments, and residential and commercial areas, those 3. And so June 10th and June 24th are both kind of being set aside for that. There are hearing items that are coming as well. I don't know where those are going to land, but you're going to be seeing a number of hearing items before you as well. Those have not been scheduled yet, so they'll intermix with that. Interesting news, probably you'll hear this on TV and in the newspaper, but the governor has taken a significant pause on I-205 tolling. That was in today's paper. So, so we don't know what that means, but it's an interesting turn of events in that the I-5 bridge will still be tolled, according to the article. It's a question mark on Abernathy since that's being built, and we have no idea what's going on there, but there's discussion around that. But essentially, it was not working. We will probably still be looking at things if that comes back in our TSP update to, make sure we're counting if that does come back in some form, what would that look like and what impact would that have? But for right now, it's the end of the legislative session, and I think it's going to be a while before that comes back, and if it does come back. So more to come on that. So I don't think that's a bad thing for Canby, and I think it's going to not cause the problems that we were, in addition to everything else on the growth and everything else, it just compounds that. So that's a little information on that. I'll keep you guys posted on it. I think those are the main items for what's kind of up and coming. We'll do another few more things, sorry. Probably another project advisory committee meeting for the comp plan in late May. Another summit number 4 in June, mid to late June. And probably another listening session with those in the outside the urban boundary that are possibly going to be where there's properties that may be expanded sometime mid-June as well. So there's many things going on right now. And I think that's about it for now, but lots going on. You'll continue to hear updates on this, and I'll keep you guys all posted on it.
And Don, there was one other request, and I can't remember which commissioner, if it was Hannah or Jenny, about adding alleyways. Somebody mentioned adding alleyways. Was it you?
Yeah.
Yeah.
I was going to request that we don't do that on April 8th with the fencing because I'm going to be 3 hours ahead on East Coast time watching an eclipse, and I'm not going to be able to join you for that exciting evening.
Okay.
Although I'd join you another time if you want to do it another time.
But alleyways will be part of the TSP for sure. We have to address the alleyways. A lot of those are owned by the city, and so their functionality, I mean, alleys are kind of a weird thing because sometimes they're private, sometimes they're public, but that will be part of the TSP. So that'll be later. That'll probably be towards summer, May, June. We'll probably be getting back into that discussion.
One of the meeting notes said something about including the definition of open space and common space with the fencing meeting. I guess then I would request that perhaps we could discuss that at a different meeting if I'm going to have to miss the 8th, because I would love to be there for it.
And I think we clearly, I think that's part of a larger discussion as well. I mean, we started that dialogue on PUDs, which is like, what is usable open space. That conversation still is important. That will come back as part of some of the housing as well. So enjoy the eclipse. So.
Thanks.
Okay, go
I
ahead.
got a couple questions for you, Don.
Yeah.
Number one, what's the status of the beer library? Doesn't look like anything has moved there for a couple of months now.
I understand that they're almost through their building permit process at Clackamas County. They're going through that process. They've gone through our process. They paid the fees, all the fees that are associated with that project. They're anxious to get going. There's a lot of carrying costs, as I understand it, that they're doing, and they're anxious to get building. I don't have an exact start date, but it's going to be very soon. So I know it's gone on for a long time, but they're really anxious to get it going.
Can I speak to that? At the mayor's state of the city last week, I think it was mentioned that they are planning on being open by this summer. So things are going to start moving pretty quickly, according to who was speaking at the City of the City.
And I think that's completely possible because all the permits are basically issued. So that, it's just a matter of their construction team getting in there and getting it done.
Okay.
Yeah.
Talk to me about Walnut Street. Where are we at?
Walnut Street Extension, okay, here's what I know. So I believe the access permit from ODOT has been issued. The design work is continuing to finish that off. It's still, I believe, on schedule for construction in '25. So that's really what I know at this point. It is a super high priority for us on many levels and affects the comp plan and other things and people's developing within the current boundary, making sure people are not using Haynes Road for the industrial access piece, which is a horrible intersection, all those things. So it is not off the radar screen and should be going out to bid as well. I mean, Public Works is driving this, but I believe it's going to be going out to bid soon as well, so.
All right. And the third thing is NitroBridge closure. Have you heard anything about that?
I've not. I know there was a delay to it, and so are they still going to, did they not do all the work? I mean, okay, so they're still, okay.
Have you heard anything, Jane?
This fall is preliminarily when they thought it might get started. Design-wise, it's pretty much going to be the same thing, just on bigger footers that are supposed to give it a little bit more support in an earthquake.
And you're speaking about the bridge, right? On
Pardon?
Knights- Which part of Knight's Bridge you're speaking?
Like the bridge
The
itself.
bridge,
Okay, yeah.
the bridge.
Yeah, so when they are working on it for a period of time, they'll have to close that down, and it might run up against some of the 99 work, yeah.
Okay. That's all I got.
So that's it for us.
Okay, Commissioner Jarosh, anything before we close?
Nothing for me. Thank you. It was a great meeting. Thank you, David, for all your information.
And Commissioner Llewellyn, anything from you before we close?
Nope, nothing from here.
All right. Commissioner Driscoll?
Last month, I was told that when it comes to the ODOT construction, pretty much it's going to continue until it's completely done. So it will just, they're not going to start and stop again at this point. They're just going to keep going until it's done. It won't be anytime soon, but just FYI, when it's done, it's done.
Thank you. Commissioner Ellison?
I just wanted to, I remember last time it was brought up, a reminder that we need to formally close the meeting, just making sure we do that.
Thank you. Commissioner Hutchinson?
I sent Don a copy of a release. It was kind of an internal release, but it's for public consumption for the city of Portland, and it was housing measures that they were going through to kind of try and streamline their permitting process and spur construction, and some of the things I saw in there were ridiculous. I mean, just artifacts of ancient things. And so, but there were other things that they entertained that we have already engaged and addressed, and so I feel pretty good about where we are, regionally. We're doing better than Portland in a lot of ways, so we should feel good about that.
Thank you.
I'm sure that's saying a lot, but okay.
Vice Chair?
People
anything?
still moving there.
Yeah.
Yeah, I'm good.
All right. Then I will entertain a motion.
I move we close.
I second.
All in favor?
Aye.
Aye. All right, we are officially closed for the evening. Thank you, Canby.